Hi everyone, it's Paul Tilley and this is LW1230 and we're talking about torts. In this particular section we're looking at the application of torts with some legal cases and applying some of the concepts. So stay tuned. I'm going to do a review of what we looked at. I've added in some cases today. We've got this, this section is really broken into a couple parts. The first part dealt with the torts and the various kind of torts. So we've ran through the various kinds of torts now, the common torts, their defenses. So that's something you really need to be aware of. Okay, what are some of the torts? What are some of the defenses for the torts? The second part of this looks at this concept of negligence, which is a tort, but it's a big enough issue that it's kind of separated out, okay? And negligence deals with this duty of care, and on the surface it seems pretty straightforward, but when you dig into it, it's a little more complex, and the courts have had to rule on this over the course of the years. So really, negligence involves either an inadvertent or careless conduct that causes injury or loss to another. If I drive down the road and I slip, my car slips, and I run into your house, and I hurt you, I didn't do it purposely, however, I still did hurt you. So that would be considered negligence on my part. The question is, when does it cross the line? There's stupid, like I was driving too fast. I was not watching where I was going. I was on my cell phone. So there's all these things that can come into play. Or I could have been doing my darndest at the speed limit perfectly, driving along, and the car slipped out from under me for no apparent reason, and it did exactly the same damage. So what the court is going to look at is, what do we define as negligence, and when does negligence start getting more negligent, or what degree of negligence, I should say. So one of the things that courts have had to deal with is how negligent is negligent. So a person owes what's called a duty of care to anyone else. And that duty of care really is kind of emblematic of the fact that my rights end where yours begin. Okay, that sort of thing. And I have to do my darndest in my normal activities of the day to ensure that I don't hurt you, either purposely or inadvertently. Okay? My rights cannot infringe on your rights. So negligence occurs when the conduct falls below that standard. So I have a duty of care, and that duty of care, the court's going to look at me and say, you know, I should do everything possible within my power to ensure that I don't hurt somebody. And the court will look at it, and they'll use something called the reasonable person test. And the reasonable person test is, what would an average person do here? Would anyone looking at this put in their, if they put themselves in your shoes, would they have done the same thing? Now, if I go down the road and I'm looking at my cell phone, I'm driving fast, that is not what a reasonable person would do. So the court would rule harshly against me on that. So that will be on the high end of negligence. However, if I'm driving down the road within the speed limit, watching what I'm doing, and something happens, maybe a mechanical problem with the car, okay, the wheel fell off or something like that, you know, the court's going to look at that and say, that could happen to anybody. So this reasonable person test is always applied by the court. To be negligent, for the court to find anyone negligent, the injury or loss must result from that conduct. So if, for example, I am in the car and you're out mowing your grass, and at the same time you slip on the grass and fall, and because you fell, you ended up under my car. You know, that's not my doing. So you have to make a connection between my negligent act and the conduct. Now, you say, well, that's a silly one. What if someone had a heart attack and died? Okay. was it the accident, my driving the car, or did the person naturally have a heart attack? You know, that kind of thing. The court needs to draw a line between what I did in terms of a negligent act and what happened to you. And the duty of care is owed to anyone who can reasonably foresee would be harmed in what we do. So I have to be able to owe you a duty of care, because if I'm driving down the street, I should know that that 3,000 pound piece of steel that I'm driving could potentially harm you. I have to be aware of that, and I have, in my mind, I should have been aware. I should have been aware that I could hurt someone with this car, and I should have driven it with all due care and standard. So if I did drive with due care and standard, great. But if I'm on a cell phone or I'm distracted in some way or another, you know, that 3,000 pound chunk of metal going down the road, considering Mr. Newton and all the laws of physics, I should be aware of that and have considered it. Like this morning, driving down the road, I should not, even the speed limit, the court would look at it and say, well, you were driving the speed limit, Paul, but the roads were very slippery. You should have driven slower. I could have foreseen that slipperiness is going to affect my car's stability. There was a famous case in England. We talked about Donahue versus Stevenson the other day. That was the snail in the ginger beer. There was another famous case that came out of England many, many years ago called the Ann's case, and it really establishes a test for determining the existence of a duty of care. And as I said, that test is really a two-part test, and that is sufficient relationship of proximity based on foreseeableness. You know, I'm driving down the street, I see there's gardens and people, and you know, if I were to slip off the road or for some reason leave the road, I could hurt somebody. I could reasonably foresee. So that test would be met in the case of me being negligent. And the consideration of reasons why there should not be a duty of care. So the flip of that is the reasons that there should be a duty of care. Obviously, I don't want to hurt you. And these sorts of things should come into play. Now, if it was a case where I'm driving down the road and you run out in front of me like a madman and I hit you and run you over, okay? So this is something that I could not possibly foresee and something that a reasonable person would not see. Now, you could argue that there was a relationship there. I should have known that if I'm driving down a residential street, someone could potentially run out. I got to do everything possible when I'm driving to make sure that there's no one around. But that second consideration wouldn't, the consideration of, you know, do you really think that a reasonable person would see someone run out in the road, or a reasonable person would run out in the road? No, it wouldn't. So that would
They'd be trying to get an insurance scam at that point.
Yeah. Well, that is the thing. You really have to ask yourself, are those two criteria met if someone runs out in the road in front of me?
Yeah, that's why whenever I get my first car, the first thing I'm getting is a dash cam.
Yeah. That would certainly help with that. So the Ann's case was really important. In Canada, in 2001, there was a similar case called Cooper versus Hobart. And this was a real estate or some sort of a dealing going on with regards to a mortgage. Someone was trying to get a mortgage. Cooper advanced money to the mortgager, and basically he lost his money. And the question was, should the person who was handling the mortgage be responsible for negligence or for losing the money? So, you know, and again, it just built on top of the Ann's case. So one of the things that the buildup has been is for professionals, okay? So this has really put a task on professionals. What we mean by professionals is people who hang out a sign that Linda Hunt was a receptionist working part-time for the Sutton group when she attended a Christmas party, and she had a lot to drink. She was pretty well drunk. At 4 p.m., she still had responsibilities to clean up the party, but her employer, seeing that she was drunk, offered to call her husband to come pick her up. Instead, she remained for 2 hours at the party before she left with several other people to go to the pub. She then set out to drive home in freezing rain and snow, and she was seriously injured when her car slipped into the path of another vehicle. Okay, so we got an interesting situation here. We got a Christmas party going on at the office of Sutton Group. The boss offers her a ride home or some way to get home. She refuses. 2 hours goes by, and then she goes out and proceeds to get more inebriated. And then she drives home, has an accident. Anyway, the damages were well over $1 million. She sued her employer for putting her into an environment where she was at risk, and she sued the pub for failing to protect her as a patron. Although the court found her behavior to have contributed to her loss, the employer and the pub were jointly and severely liable for 25% of the loss. Joint and several liability means that if one of the defendants can't pay his share, the liability is assigned to the other one. Judicial decisions in Canada have made it clear that employers and commercial establishments serving liquor can be held responsible for injury and loss suffered as a result of serving liquor to the point of intoxication. Care should be taken to ensure people don't drink to excess and that alternate transportation should be arranged. While such liability has not yet been extended to private individuals in this country, it would seem prudent for private hosts to make sure their guests get home safely if they've had too much to drink. Now, this case and the ones like it has had a huge impact on work, particularly drinking alcohol at work, parties at work, and these sorts of things, okay? This has sent a chill over the workplace of anything like this going on. In fact, I know in the province, for example, it's mandated that that sort of thing cannot go on because of this particular situation. The other situation that causes some problems, it has imposed a very high duty of care on bars. If you go into a bar, they need to ensure that you don't have too much to drink. And if you did, they have to ensure that they get you home safely because they're opening themselves up to liability if something were to happen. The third part of the case says this hasn't been extended to private individuals yet. Well, this is something that hasn't been tested yet, but there's fear that it will happen. If I host a party in my house, you come to my house and you get too drunk or have too much to drink, then you take your car and drive home and you're hurt, you could sue me because, again, it would stand to reason if that rule applies to employers, that rule should also apply to party hosts. So there is a lot of concern in the public sphere about holding parties at their homes now where they don't take great care to ensure that their guests get home safely. Now, the most famous case is Donahue versus Stevenson, and this is really this case stretches over two parts of this course. The first part here, we're talking about torts, okay? Wrongs that are performed against someone. And in the case of the decomposing snail and the ginger beer, there certainly was a wrong. Mrs. Stevenson opened up the bottle, or Mrs. Donahue opened the beer, poured it over her ice cream, and then realized there was a snail in it. She got very sick. So she could certainly sue the manufacturer for problems there. But the thing is, as we move into contracts, we're going to find that Mrs. Donahue could potentially have had a contract with the supplier of the beer. If she bought the beer, for example, from the supplier, then drank it and found it was bad and got sick, she'd have a contractual legal case against. But in this case, she was given the beer. It was her friend gave it to her. So I just want to watch this little video to show you some of the permutations.
From the United Kingdom in the House of Lords in 1932 comes perhaps the most famous case in law, Donahue and Stevenson. On Sunday, the 26th of August, 1928, May Donahue met an unidentified friend of hers at the Well Meadow Cafe in Paisley. Miss Donahue's friend ordered herself a pear and ice and a Scotsman ice cream float, which is a mixture of ice cream and ginger beer, for Miss Donahue. The two ladies enjoyed their desserts. However, when Miss Donahue's friend poured the last of the ginger beer onto Miss Donahue's ice cream, the decomposing remains of a snail fell out of the bottle. Miss Donahue was sickened by this image, knowing she had consumed the liquid this snail had been floating in and began to feel pain in her abdomen. She consulted a doctor 3 days later on the 29th and was admitted to Glasgow Royal Infirmary for emergency treatment on the 16th of September. There she was diagnosed with gastroenteritis and shock. Miss Donahue sought the services of Mr. Walter Leachman, a local solicitor who had acted in a similar case some weeks earlier in the case of Mullen and A.G. Barr and Company Limited. A writ was filed by Mr. Leachman on the 9th of April 1929, claiming the sum of £500 in damages, which would be £28,900 in today's 2017 money, and £50 in costs, which would be £2,890 today. As the common law stood at the time, a person only owed another person a duty of care when that person was harmed by the negligence of another person. That is, it was quite limited to more or less direct or indirect actions. As there was no contract between Miss Donahue and the manufacturer of the ginger beer, he did not owe her a duty of care. However, the court held that a manufacturer does indeed owe a duty of care to the end customer, as the purpose of their product is to be consumed. Therefore, the absence of a contract between two parties does not mean that one does not owe a duty of care to another. Lord Atkin famously enunciated this neighbour principle, that one must take reasonable care to avoid acts or omissions that could reasonably be foreseen as likely to injure one's neighbour. Miss Donahue was successful in her claim, although the case settled outside of court in 1934 for £200, which would be £13,141 today. Mr. Stevenson had a duty of care to ensure that snails did not get into his bottles. Of course, there is something to note in all of this. Surely one could inspect a glass bottle to check for snails and anything else out of the ordinary. This is true. However, the bottles Mr. Stevenson used were opaque and thus could not be inspected by a prospective consumer, meaning that the manufacturer had the duty to make sure they were not selling decomposing snails to old ladies. However, that is where the silliness and the humour ends, as nobody lived happily ever after. Mr. Stevenson died in 1932, leaving his estate to settle the case in 1934. His business was taken over by his family and became a limited company in 1950. The manufacturing plant was demolished in the 1960s, and the Well Meadow Cafe, where it all began, closed in 1931, with the building demolished in 1959. Miss Donahue, perhaps from the stress and illness of the case, died of a heart attack on March 19, 1958 in Gartlock Mental Hospital. And such concluded the case of the snail in the ginger beer.
So Mrs. Donahue really suffered for that. She might have been, and that brings up another point that we'll look at in law. Maybe she had some mental health issues to start with, and that certainly put her over the edge. But there's another situation in law that's called that you take your victim as you find them. And if, for example, you hurt someone, and in terms of negligence, but you say they were particularly prone to being hurt. Let's assume they had a bad back, and you bump them with your car, and then their back gets worse. And you say, well, you know, their back was bad to start with. How can I hurt them? But the fact is, in law, the argument is that negligence applies regardless, because you take your victim as you find them, and if they are already of I think the word was weak nature that they used in the court case, you have to, that's not going to affect the outcome of the decision. But the fact is that Donahue and Stevenson is one of the most famous court cases that deals with this concept of negligence, and it really established the foundation for modern law with regards to negligence. That's where it came from. And as I say, that's just a write-up. We've talked about the duty of care. So you as an individual going down the street have a duty of care. And that's the first part of the Ann's case. The first of the two Ann's, when we look at when we look back at Ann's, the fact that there was a requirement for sufficient relationship proximity. Okay, so I just happened to be close to you and I bumped you. Considerations for reasons why there should be a duty of care. And the reasons of why there should be a duty of care applies really to, as I mentioned, people like professionals. So a lawyer, a dentist, a doctor, these types of things. And instead of it being a duty of care, when we think about professionals, or that second point of the Ann's case, what we're talking about there is a standard of care. We would expect, for example, that a doctor will have a standard of care, meaning that if you're going to get operated on, that doctor has met all of the standards of the medical association to be able to know where your stomach is, or where your eyeball is, or where your brain is when they start making a cut. So they're not, you don't have someone who's incompetent to do an operation doing operations. So there are minimum standards of care that are imposed on professionals. Normally it is imposed, that standard is imposed by their professional governing body, such as the nursing association, or the doctors, the medical professionals, or the engineering societies, or whatever, or the law society. So the law points that there is an existence of a standard of care, and it should be relatively self-evident. You expect your doctor knows what he's doing. The problem is to determine whether there's a failure to live up to that standard of care. And that's always a question, is did you live up to the standard? And if your patient dies on you and you're a doctor, how can you prove that the doctor didn't do everything he or she could in order to save you? In general, the law does not impose a duty to act, so omission is generally not actionable unless there's some relationship imposing a duty. That's an interesting one too. So if you're a doctor, for example, we've all seen the movies where they're on a plane or on a boat or on someplace, and they call out over the loudspeaker, "Is there a doctor in the house?" Well, there is no duty to act. So if the doctor says, "No, I'm just going to keep my mouth shut here, and I'm not going to go offer any help," there's no legal duty. There's a moral obligation, but not a legal obligation to go and help, unless there is some imposed duty. So, for example, if you are a lifeguard in a swimming pool, you can't argue that I didn't have a duty of care to do anything. I could sit up there and do nothing. No, you're a lifeguard. Your job is to go and ensure that people are safe in the pool. So you can't get out from under the rule, the duty of care, the standard of care, by saying, no, I didn't want to deal with that. The lifeguard, by definition, is responsible for dealing with that. And that's a thing called feasance or non-feasance in the case of no action. So foreseeability comes into play. The level of risk, the cost, and the potential loss are all factors that the court will look at with regards to this standard of care, okay? The standard has to be applied for, let's say, an engineer. The standard has to be applied. There has to be foreseeability that the building will fall down. The level of risk, if it does fall down, will someone get hurt? The cost, well, we could build a building that won't fall down, but it will cost a fortune. So we need to factor out how much cost is involved in order to ensure that level of security, and the potential loss. So experts held the standard of care are really held to the standard of their profession. As I say, the professional body puts it together, and circumstantial evidence. So it could be loose evidence could be found to find negligent. So there really has to be if you were to take your engineer to court, for example, or you take your lawyer to court, or you take your doctor to court, what you got to do is to make a connection between the loss, the cause of the loss, the duty owed, and the fact that the duty was breached, and that there are no defenses on the part of the doctor, let's say, or the engineer. let's just take a look at this. Let's just take a look at this particular case, and this is one that illustrates a professional event. So this is accounting, Cripps versus Touche. Defendants were a firm of accountants that audited the books of the Victoria Mortgage and Housing from 1980 to 1983. These audited statements were used to issue a prospectus to sell debentures to the public. So what we're doing here is raising money for this firm. That's effectively what they did. Debenture is just some form of a loan that they get from the public. So you're selling some sort of a instrument. The auditors refused to approve the 1984 statements of the company that led to its collapse. The debenture holders, who had relied on the previous statements, which were ones from 1983, lost considerably in the collapse and sued the defending auditors. The debenture holders claimed that the auditors had been negligent in providing a favorable audit in prior years. The problem relating to the number of mortgages held by Victoria Mortgage that were in default. They amounted to 1/3 of the mortgages held by the company, and the bad mortgages have been capitalized as valuable assets along with the unpaid interest instead of being treated as uncollectible losses. So, okay, just kind of translate that. Effectively, what this accounting firm did is they went in and they looked at this bank or this mortgage and housing company, and they said, now, what is the chances of these mortgages not being paid? Okay, so from 80 to 83, they had to test whether or not these mortgages were going to be collectible, and they said, yeah, most of them would be. The reality was in 84 that didn't happen. The company went bankrupt. So the auditors defended their actions by stating that this was consistent with the rules that they followed, and this is generally agreed upon accounting principles that you learned about. And so long as they acted within these rules, they couldn't be held as being negligent. The trial judge agreed, but the appeal court, so it went to trial, and the trial court said, oh yeah, the accounting firm did his job. Then it got appealed, and the appeal court found that the auditors were negligent. Professionals cannot hide behind rules that they make themselves and claim that they are following the appropriate standard, no matter what the consequences. GAAP may be their guide to forming this opinion, but auditors are retained to form an opinion on the fairness of the financial statements, not merely on the confirmation with GAAP. The auditor knew the mortgages were in default at the time, thus making the audit statements clearly misleading. So the case illustrates the high standard of care required by professionals. So what we got here is we had a case where this particular auditing company, Touche Ross, went and did it to the standards of GAAP, but still the court found, no, you didn't go good enough, because it shouldn't have been the accounting standards that you were using to measure. It should have been the measure of the clients. What were the chances that the clients would lose money? So this is an interesting case that held a very high standard of care. So these are some of the terminologies: duty of care, failure to take care, and causation of damage. What normally happens is okay, someone's going to sue someone for not holding up to that standard of care. And what we're going to look at now is, well, okay, what are some of the potential arguments that they could shoot back with? Well, there's really three in terms of defenses. Contributory negligence. In the case of the lady that went out and got drunk and then went out to party all night, was involved in an accident and sued her boss, you'll notice if you look at that case, if we go back and just kind of look at that case, we got to get past this one. The court, in this particular case, she sued her employer. The pub were held jointly and severely liable for 25% of the loss. So what that is really saying is that the loss was $1 million, but they were only responsible for 1/4 of it. And this is what's called contributory negligence. So if the plaintiffs contributed to their own loss, he or she must bear some of the responsibility. So in this case, when she went and got drunk, she still bore some of the responsibility for that. So it's not black and white. It is a gradient of how much responsibility do the plaintiff and how much responsibility do the defendant bear. And it's somewhere, the proportionality is determined by the court. We've also got this voluntary assumption of risk. And as we talked about there, if you go in full knowing that some of these things are risky, you have to anticipate that you're going to end up with potential danger. So the voluntary assumption of risk is deliberately putting yourself in harm's way disqualifies one from suing for injury or loss that results. The plaintiff assumes both physical risk and activity as well as the legal risk. Now, when I go skiing, for example, if I were to go to White Hills and I buy a ski pass, one of the things that I notice on my ski pass is that the resort is not responsible. It says right on the thing, the resort is not responsible if I fall down and break my leg. Okay? That's the thing. So what they're really saying is that I am voluntarily assuming that there is a risk in skiing. I should recognize that and don't come to them if I hurt myself. And that normally works, provided that it doesn't get them out under. If someone left something in the path, say there was a piece of snowmaking equipment right in the middle of the path, and they should have known, again, you must be able to anticipate. I would argue that the resort should have known that that piece of equipment, I could potentially trip up in it and hurt myself. If I can prove, from my point of view, suing the Hill, that was not within the realm of that voluntary assumption of risk, I could be able to sue the resort. So one of the things that we look at is whenever we get these, here, for example, I hear it all the time in town. Well, we'll get people to sign a waiver. Okay, these waivers are not normally worth the paper they're written on, because all it will do is protect against accidental damage that they do to themselves. All they need to do is find that I was libelous in some way for doing something or not doing something, and I suddenly am someone who's going to get sued. We also look at this remoteness, and we must determine whether a particular injury was reasonably foreseeable, and connection between the conduct and injury was too indirect to be expected. So, for me to go down the road, to drive my car down the road and the wheel to fall off, I could argue that was just so remote. The chances that happen are so remote that I shouldn't be held liable. And the court will judge that accordingly. But, wheels and things have come off cars before. It's not as if it's unknown. So the court would probably say, it's not that remote. I should have known. I should have taken care. Here's another example of these types of defenses coming up. Mrs. Malinsky was 73 years old when she caught her shoe and fell down a flight of stairs in a parking area. She claimed that the area around the top of the stairs had not been properly maintained or constructed. After the accident, her shoe was found caught in the gap between some patio blocks and plywood where the stairway started. The defendant argued she wasn't careful, and also that they had only purchased the company 6 days earlier and couldn't be held responsible. In finding for the plaintiff, the judge made it clear that the Occupiers Liability Act that they are responsible for ensuring their property was safe and in good condition, even though they had just purchased it. Ms. Malinsky held 20% responsible because of her contributory negligence. All provinces have similar statutes imposing an obligation on suppliers to make sure the property is safe. So we got a situation.
6 days, that should be enough time to at least do like a quick once over, at least.
Yeah. And that's the thing. There's this idea of someone arguing, well, I just bought the property or I hadn't looked at it in a while. That doesn't hold. The law clearly says that once you own it, you are responsible to ensure it is safe. This is why, when you buy a property, if you're a commercial operation and you buy a property, you really need to get a good inspection of it before you ever open it to the public. And most times those inspections are done in terms of fire safety and the like, because that's the most potential chance of injury is fire and things like that. But effectively, you can't overstress the need for businesses to ensure that they maintain their property. And they're going to say, well, there's a remoteness. The chances of getting a heel cut was so small. Yeah, and you can see contributory negligence coming into play. You should have known, or you didn't watch where you're going, or you're doing it in the dark, or whatever. But the fact of the matter is that normally the company is going to be held responsible. The other issue, again, and this is still very much Donahue versus Stevenson, where we look at product liability. Plaintiffs must show the defendant failed to live up to the standard of reasonable manufacture. And that's exactly what Mrs. Donahue did. The tort action must demonstrate the defendant did not live up to the standard of a reasonable manufacture in the circumstances. There's lots and lots and lots and lots of cases out there that looks at, did the manufacturer take very good care? There was a famous case when I was in university of, what is the name of the tin tuna? Anyone buy tin tuna? What's that stuff? Who's the company? Ocean. It's written right on it. Tin tuna is made by Cloverleaf. Cloverleaf, that's what it was. And Cloverleaf had put out a bunch of tuna that was tainted. It was called the tainted tuna scandal. And they were found responsible because they should have known, and the reasonable manufacturer, that tuna was a substandard quality. And this is where you get all these product recalls now. Companies will ensure that products are recalled rather than hit the customer if there's any question at all with regards to their safeness. The Mustafa case is mentioned here, and it's again, it's a Canadian case. So there's lots of cases, but this is just a famous Canadian one where Buddy had purchased a bottle of water from Collagen, which is the water purification company. So he'd been a customer for 15 years. The last time he witnessed the delivery, he saw a dead fly and parts of another dead fly in one of the unopened bottles. The image severely scarred him, causing significant psychological harm. So let's be careful of what happened here. He bought some bottled water. He looked in the bottle and he saw a fly floating in there, and it grossed him out. Okay, so that's basically what happened. The image severely scarred him, is what he said, and it caused significant psychological harm. That was his argument to the court. He sued for this harm, and anyway, the fact is that Collagen were on the hook for this. In this case, it is clear that there was a duty of care owed, as the manufacturers owed a duty of care to the customers, okay, based on Donahue versus Stevenson. So certainly there was a problem there on the part of Collagen. They had to make sure that there was no flies in their bottles. It's also clear that the Collagen's conduct breached that duty. Their duty is to make sure to give pure water. That's what they say. Doesn't include flies. There was definite damage suffered as I can't pronounce his name, Mastropa, developed a major depressive disorder, which had significant impact on his life. It also proven that damage was caused by the breach of duty. However, it was just so remote that the fly, him seeing the fly, would cause psychiatric harm to a reasonable person. So, he was seriously affected, no doubt about it. But the court looked at Collagen and said, okay, so what's your excuse? And they said, well, it's just so remote that someone would be that put off by this. And the court basically reduced the compensation based on that. The fact that it was, he was, again, that you take your victim as you find them. But in the meantime, they say, well, okay, let's assess whether he was actually harmed. And he wasn't. Okay, so we look at product safety. Here's an example of a product safety case. In this case, Mr. LeBlanc was seriously injured when using the defendant manufacturer's product. He was repairing the floor in his van using the kit produced by Marsden's Canada when the tube of hardener burst at the wrong end, spraying into his face, causing temporary blindness. Although he recovered his eyesight, his eye remained so sensitive to the fumes that he had to quit his job as a furniture finishing refurbisher. There's no question that the duty was owed to the user of the product under principles Donahue versus Stevenson, but the defendant claimed that they had met the required standard of care and they were not negligent. In other words, they built a tube that had relatively good quality to it. You really can't, if someone goes and stomps on a tube or does something with a tube, they can't be held responsible for that. That was their basic argument. The court found, although they had done some testing on the tube, the testing was inadequate with respect to how much pressure could be exerted before bursting the tube. They also failed to warn the user of the danger or to recommend that the user wear protective gloves and goggles and clothing. The lack of warning and inadequate instructions was a result. The tube was a recipe for disaster. The damages were awarded over $75,000, and Mrs.'s wife, the wife was awarded $2,500 for her trouble. The case not only indicates the great care that must be taken by manufacturers and resellers to anticipate the control of how their products are to be used or what can go wrong, but also proper instructions. So this really has been a bit of a watershed case because it's really imposed a very high standard on manufacturers to say, look, you've got to anticipate anyone doing anything with this. And this is why these things tend to be yanged up with all kinds of safety notices and the like in order to minimize the liability on the potential manufacturer. The professional liability thing too, and as I say, this is this high standard. In terms of it, we got some terminologies there. Inexperience is not a defense. You can't say I'm new at this. There's something called a fiduciary duty, which is a duty to act in the best interest of clients. This is what doctors basically have in their Hippocratic oath to save lives. Subject to the rules of professional association, liability insurance comes into play. This is why all doctors have insurance and lawyers have insurance to cover this sort of thing. And negligence could be considered as criminal. I got, that's too hard to read, but I got a case there. Here's an interesting case that happened in Canada not too long ago. And this was a case of an engineer, civil engineer, Mr. Wood. And effectively, he had gone into a mall. He was hired by a mall in Elliott Lake, Ontario, to take a look at the mall and see if it was structurally sound. He basically wrote a report that said, yeah, the mall's all right. And shortly after that, the roof of the mall fell down and killed 2 people. Now, the question to the court is did he owe the standard of care that he owed as an engineer? What was that? And did he live up to it? And the court ruled, no, he didn't. He didn't live up to his rule, to that rule. The court didn't go as far to say his actions were criminal. So, but he basically really did not do a good job at the job. He did not live up to the Engineering Association's rules. So you got to be careful with that. The final thing in this unit is this concept of trespass of chattels. And this is, wow, this is a really weird terminology, but effectively it means you can't steal someone's intellectual property. Okay, so if, for example, you had a logo and someone goes and rips off that logo, or if you had a brand name and someone goes and rips off that brand name, so what you can do is sue for trespass of chattel. So you sue in tort,